CNA welcomes the federal government's moderate approach to this challenging legislation, and we support the expeditious passing of this bill. CNA strongly endorses the stated intention to work with the provinces and territories on a pan-Canadian care pathway for end-of-life care, which has the potential to reconcile issues related to access and conscience.
And with regard to conscience rights, we've heard in some testimony that conscience rights should actually be explicitly stated in this law. What I'm wondering is, of course, this is an amendment to the criminal code, and I'd like your views on whether you feel that would be appropriate to insert in the criminal code itself. It's in the preamble now. What are your thoughts on that?
Well, I think suggestions have been made about saying, well, nobody shall be coerced to perform medically assisted dying or participate in it. And I think you could put that in the criminal law, but my sense is that's not the real concern. The real concern isn't coercion in the sense of, a gun to your head. The real concern is, professional repercussions if you don't participate. And if that's the real concern, I think there are limits as to how far the feds can go. And it's not a criminal code provision, I don't think, but in federal jurisdiction, you've got military hospitals in terms of, professional consequences, but that's not a very big part of the picture. If you're talking about essentially discrimination against people for exercising their conscience rights, the Canadian Human Rights Act has a very limited application generally, and specifically in a way that could implicate people conscientiously objecting to medical assistance in dying. So, I think there are some things that could be done, but mostly it would be difficult for the feds to go very far with this. But, the ministers have been saying nothing in this act requires anybody to do anything, and that's true. The question is, do you have more robust statements of that? And I think you may be able to go some distance, but if you're looking for sort of the strongest protections, it's provincial jurisdiction.
My second point is about what is often called freedom of conscience, but is also about protecting healthcare services from becoming death-promoting environments and thereby protecting patients from those environments. I suggest you include in the law a prohibition against requiring any health professional to cause the death of a patient or to refer a patient to another person to obtain their death, even through a third party, as is the case in Quebec, and against requiring any healthcare institution to euthanize patients under their care or to assist in their suicide. There's no justification for imposing any duty to implement this political decision, which is foreign to the medical profession, on medicine as a whole or on any individual practitioner or institution. Attempts to do so are already being seen, both in Quebec and in Ontario, through requirements to refer. The federal law cannot just leave this question to the provinces. In Quebec, since December, doctors who are unwilling to euthanize patients must refer them to an administrative body that will ensure the death occurs. This does not protect the patient or the professional integrity of the physician. If I were a surgeon and a patient asked me for a procedure that I thought was either not going to help them or would be too risky, I would refuse to do it, and I would also refuse to send the patient to someone else who would do it. They would, of course, be free to go and find a doctor of their choosing if they wanted to. In palliative care in Quebec, one excellent palliative care physician has compared her daily life under this law to living in a war zone. You never know when a death request is going to land on you. You can't be giving hope to dying patients in one room and euthanizing them in the next. Another doctor retired early the day the law came into effect for this reason. Highly skilled doctors and nurses who have given years and decades to the care of dying patients are suffering burnout, taking sick leave, and being driven from the field by confrontations over a supposed right to be killed, by threats of losing funding if they insist on caring for people rather than killing them.
Secondly, you also spoke about, in the next page of your submission, you spoke about there being no justification for imposing any duty to implement this political decision on Canadian doctors and institutions. Do you feel that Canadian doctors would be forced to conduct medical assistance in dying?
Well, in Quebec right now, Canadian doctors who are not willing to conduct it themselves are obliged to send the patient along a path that will ensure that it will be done. So that, to me, is similar to what Dr. Blackmer mentioned about Ontario, which requires referral directly to someone who will do it. And most people who object to euthanizing patients would also object to sending them to their death, not because of our own needs, but because we think it's contrary to the needs of our patients.
Okay. I don't know if Mr. Akiko, you have any opinion on that?
Well, you see, the doctors also have a right to freedom of conscience. And a doctor who feels that it should not do that for its own conviction and for the good of his patient should not be obliged to do it, and should not be obliged either to refer to someone who would do it, as is the case in Quebec. And I think it is very important that if we have to have this law apply equally and similarly across the country, that this committee recommend that the objection of conscience, both for individuals and institutions, be implemented. And I personally think that you have the jurisdiction because it's ancillary to your jurisdiction over criminal law. In Quebec at the moment, certain hospitals do not perform abortions, and they're not forced to perform abortions, but they're forced to perform medical aid in dying. This is why we need the institutions to be protected as well.